This is Agriculture Today. We are joined now by Roger McEowen. He is a K-State and Washburn University School of Law professor that joins us every other week to provide an ag law update. And today he's going to be speaking with us about marital deductions and QTIP trusts. So, Roger, a little bit interesting. We're not cleaning our ears here today.
QTIPs are more than just what you stick in your ear. It actually is a pretty advanced estate planning concept, and it gets kind of detailed. But in farm and ranch estates, they're complex by nature because we're dealing with a business in many situations. And QTIP trust is just one avenue that allows a larger estate to still take advantage of what we call the unlimited marital deduction and leave the property to the surviving spouse in a form other than outright, which is normally the rule for receiving an unlimited marital deduction.
Sure. So good to know of. And another reminder on why succession planning is so important, even if you don't foresee that being something in your future anytime soon, right?
Yeah, exactly. And a lot of the times what we want to do is we want to provide something for the surviving spouse for life, and then often it's a remainder down to the children, particularly, maybe one child of several is going to take over the farming operation. And so we want to kind of split the estate up, let the spouse benefit from the property, live in the farmhouse, get the rent from the property while the spouse is living. And then after the surviving spouse dies, then the full ownership and use and possession of the property comes into the hands of the children. The problem we have under the federal estate tax rules is that we can't get an unlimited marital deduction on property that passes otherwise than outright to the surviving spouse. And that marital deduction, as I indicated, is unlimited. We could have somebody such as a Bill Gates or a Warren Buffett with billions of dollars leave everything to in Buffett's situation, leave everything to the surviving spouse. And there is no estate tax. It doesn't matter how much is left outright to the spouse. It's tax-free. And you can do that during life. It's an unlimited gift tax amount, and you can do it at death. You can leave as much to your spouse as you want. There's no tax on it, whatever the amount. But the problem is that may not be the best plan because then you're loading up the surviving spouse's estate with a lot of wealth, and there could be potentially a tremendous amount of tax in the second estate. So a typical plan has been that we kind of balance the estates during life, get an equal amount of value in each spouse's name, and each leaves the other a life estate in a portion of the package that will optimize tax in the first estate and utilize marital deduction on the other package. Well, a concept came up back in the 1970s, and I think it was probably because there were people in the Congress that were serial marriers, one spouse after another spouse after another spouse, and they would want to benefit the spouse to whom they're married to at the time they die, but yet leave property to the children of a prior marriage, which, if you think of a farming operation and we have divorce and remarriage, that farm is probably going to want to be kept in the line of the children that were the result of the first marriage. That's often what we see. Well, if we've got a sizable estate and now we've got a federal estate tax issue, and this will become a bigger issue as we get closer to 2026 because that exemption is scheduled to drop under current law. If Congress does nothing, that exemption goes to 5 million inflation-adjusted dollars, so probably about 7 to 7.5 million. With the inflation adjustments, it will be in 25 probably about 15 million. So it's effectively going to get cut in half if Congress does nothing. So this concept becomes a bigger deal in these situations where we've got mixed families and multiple marriages. I don't want to necessarily leave everything outright to the spouse, but I got children of this first marriage, and those are my farming heirs. So the QTIP concept was developed probably because people in Congress had the same problem as an exception to the rule that you have to leave property outright to the spouse. So we can leave some of that in life estate form, but it has to be in a qualified form, qualified as a QTIP, and then remainder down to the kids.
So when it comes to setting up a QTIP trust in this situation, what does that process really look like?
Well, it's an irrevocable trust. It's set up, the terms of it are placed in the decedent's will, which establishes the trust. So it's a trust created under the terms of a will. It's a testamentary trust. It takes effect at death. And it has to have certain language in it to qualify. The spouse has to be entitled, has to be the only person that's entitled to the property, the income from the property for life with payments at least annually, and nobody has the power to alter that during the spouse's life. Those are your three requirements. And you can't appoint it to anybody other than the surviving spouse during the surviving spouse's life. And an election has to be made on the deceased spouse's estate tax return. So once you get through those requirements and you have the right drafting in the document, then we can qualify the property going to the surviving spouse in a life estate form for the marital deduction and still move it to kids of a prior marriage, for example. And it's a very tax-efficient way to do these things when we're dealing with these kind of complicated family matters.
Yeah, complicated to say the least. And you mentioned that this was started 1970s, kind of?
The concept came in the 1970s.
Okay, so as time evolves, things change, society changes. Are there still successful cases of this that happen today?
We just had a recent QTIP case out of the tax court, and it wasn't a successful case from the taxpayer standpoint. They kind of messed it up. And I even wrote in my recent blog article on this that I wondered why they even used a QTIP trust in this situation. And I suspect that Dad, if he died first, which he did, suspected Mom would not benefit the children. And indeed, that is exactly what happened. She ended up leaving her property to charity and not to the kids, but he had protected the kids by giving her only a life estate in certain property, and he had specified that that property was to go to the children. And this was a multi-million-dollar estate. We're talking 50, 60 million. It was a large estate. And he set it up as a QTIP so he could still get the marital deduction and wipe out estate tax in his state. Now, they screwed up some other things. There was debt involved and a lawsuit settlement and how they handled all of that. It was a really complex case. But it just shows you where a QTIP can fit and how it has to be done properly to get the right tax result.
Sure. So still a reminder that those requirements are there for a reason. They need to be fully followed at the
That's right.
followed through. Wonderful. Well, that was an example of where it's gone wrong. But like you said, there are plenty of examples today, right, where this does go right and it's a successful transition for the family.
Yeah, and it comes in handy in farm and ranch estates. Again, as I said, often we're dealing with a business and we want to transition the business to the next generation. Well, what if you're not dealing with the initial spouse or the parent of the children that are eventually to take over? It's a subsequent marriage. And this is one way to keep the operation intact, keep it in that line. In agriculture, we're very particular with respect to bloodlines. And I've had this conversation with many farm wives over the years. And look, you're not in the bloodline of that family. And so that's an issue for some people. And we want to keep it to the children of that marriage. Well, if there's been a subsequent marriage, this is a technique that allows you to get the estate tax benefit and keep the property inside the family and benefit the spouse for the spouse's life, which is usually desired. But then we want the property to come back to the children of a prior marriage. And this is why that technique is there.
Absolutely. So a win-win across the board for all parties involved when done correctly.
When done correctly. It's again, ag estate planning can be very, very complex, and this is one of those complex tools. When done right, can really provide a good benefit.
Sure. So would that be your advice to producers that are maybe, dealing with a similar situation or maybe are on the edge of I don't even know where to start with succession planning, is kind of thinking through maybe this is one of their options?
Yeah, and get good tax and legal advice. This is not something you dare do on your own at all. It's very, very complex. But if you do have a complicated family situation and a desire to keep the farming operation in the family, you need to have good legal and tax advice.
Roger, I know you wrote about the subject you mentioned in a recent blog post, so more information on it can be found in that article that Roger wrote, and that can be found on his blog as well as agmanager.info, right?
That's correct.
Absolutely. Well, I'll be linking to both of those resources because they really are valuable when it comes to succession planning topics like this one. At least it's a good foundation to start with. And then, like you said, seek greater legal help beyond.
And that's the key. That's the key to it all.
Absolutely. Well, thanks so much, Roger, again, for joining us today. I appreciate it.
Thank you, Samantha.
Once again, everyone, that was K-State and Washburn University School of Law professor Roger McEowen joining us for a Ag Law Update.